Call this meeting to order at 10:30, Wednesday, August 28th, 2024. We're here for discussion on the David McQuade vacation of right-of-way with planning and zoning. At this time, I would entertain a motion to go into a public hearing.
So moved.
Second.
All in favor?
Aye.
All right. I'll skim the rules since it looks like the same crowd as the last one there. Please sign in if you wish to speak, and then indicate whether everybody's already done that, so there's no point. No person permitted to speak until they've been recognized. All public hearings shall be recorded. Please don't interrupt the speaker. If you have evidence of any kind, please submit it in 4 copies. And let's engage in a respectful manner with the person speaking. Once the hearing is closed, no further evidence or testimony will be presented or considered. That is the rules of the hearing. At this point, let's see. We have the same as last time, so I'll give you that, Heather.
Thank you.
Let's go to the staff report.
Thank you. Dan Martinson for the record again. This is an application by David McQuade, petition to abandon and vacate a portion of Potlatch Road right-of-way within Shoshone County. This is case number VAC 1002-23. Similar to the last one, I'll breeze through these. On June 23rd, a complete application was submitted to Planning and Zoning. Notification was published on July 26th of 24, August 9th of 24, August 20th of 24 in the Shoshone News Press. July 24th, notification of the adjacent property owners within 300 feet was sent to each owner within 300 feet via U.S. Postal Service. And on July 26th, a physical posting was placed on site. Public meeting was scheduled for today, August 28th. And the findings of the fact of this case are very similar. It's literally across the street and uses actually the same record of survey and the same exhibits as the previous case. The applicant is David McQuade of 9064 Potlatch Road in Calder. Property owners are Thomas McQuade Revocable Trust and Catherine McQuade Revocable Trust, 9064 Potlatch Road, Calder. The proposal is petitioning the county to abandon and vacate 1.01 acres and 0.1 acre portions of Potlatch Road because they have property on both sides of the road. Portions of Potlatch public right-of-way as described in Exhibit A, A3, and depicted in Exhibit B, A4 in your package. Subject right-of-way was acquired as fee simple property by Shoshone County via final decree of quiet title, CV 2017-94, instrument 500807, recorded September 12, 2019, which include a portion of Potlatch Road right-of-way adjacent to the applicant's properties located at 9064 Potlatch Road, Calder, aka parcel 45 North 03E 140250, and property located at parcel number 45 North 03E 11 9600. The sites are located east of Calder, Idaho, and described as 9064 Potlatch Road in Calder. There's legal description for them. Parcel numbers 0250 and 11-9600, as stated before. Zoning in this area is natural resource. Existing surrounding uses are residential and timber, recreational. Comprehensive plan designation is before. The comprehensive plan designates areas the South Shoshone District. This district allows for this kind of a thing and is rural in nature, doesn't have the same pressures for development as other county areas. The findings of also are a portion of the right-of-way the applicant is requesting to be abandoned and vacated is not improved for public or private use. A portion of the public right-of-way is not necessary or required to provide access to property which is owned by the applicant. No property is left without access to public right-of-way or abandonment. It is in the public interest to abandon and vacate the excess right-of-way and place the property into private ownership, which may be taxed so as long as the order reserves easement for existing public and private utilities. Again, this is not within an area of city impact, so no incorporated cities were solicited for comment. The Public Works Department was solicited for comment in a similar letter on September 14th, 23. Stephanie Featherstone with the Department of Public Works indicated that Shoshone County agreed to vacate 50 feet of right-of-way. They want to keep no less than 100 feet of right-of-way for their uses. Avista, in an email dated September 2023, Luann Weingart of Avista indicated that the portion of the applicant's request includes an Avista easement recorded on August 9th of 1999, instrument number 646947. Specifically, the proposed vacation area of 9064 Potlatch Road. The easement will remain intact with no intention of release by Avista, as it covers a significant amount of underground distribution line that serves the area. Additionally, Avista requires an easement for existing facilities on the north part of the proposed vacation right-of-way along Potlatch Road, indicated by GPS coordinate. Simply Fiber was solicited for comment, and as of the writing of this comment, has not responded. However, any easements that they have there would remain in place per the Idaho Code directives and our conditions of approval. As of the writing of this report and leading up into this hearing, there's been no comments from the public or even inquiry for that matter. Section 3 lists the different county codes as well as Idaho codes. Specifically 3.05 mentions 40-203. Later we'll make a typo correction for that one. Section 4 is the recommendation by the planning administrator. The recommendation of the administrator is based upon the submitted application materials, agency comments, and public testimony. Pending testimony of the applicant as well as additional public testimony, it is the recommendation of the administrator to approve the application with the recommended conditions of approval based on enough evidence that the general standards as stated within the above applicable standards have been adequately addressed. We put in there draft conditions of approval. Those conditions, in summary, say that you'll continue to meet all other state and federal requirements, and particularly Public Works and Avista. We'll go on to the approval shall run with the land and remain valid upon change of ownership. Future assigns an interest in the property will follow these conditions.
Good.
Board of County Commissioners shall cause any order or resolution to be recorded with the county records and the official map of the highway system to be amended as affected by the abandonment and vacation. All existing easements of record shall be reserved and maintained for the continued use of existing sewer, water, gas, electric, or other similar utilities, pipelines, or appurtenances. The applicant shall file and record a lot consolidation deed incorporating the abandoned and vacated right-of-way into the adjacent lot so that only one lot exists. And then we made note on the last case that there should be a condition in there, and we'll have you amend that when the motion time comes, that all particular application fees and fees paid for the advertisement and mailing notices shall be paid prior to recordation of the resolution or order and any deeds. Move on to the draft conclusions of law. We pulled 7 of those from those different ordinances and codes and find an affirmative of all of those. If you want to change or talk about any of those, you should. And then the recommended motion we put in there based on these cases, we want to make an amendment to this one where it mentions Idaho Code. In here it mentions says 42-203. We want to change that to 40-203. And then you want to add on the additional conditions when you make that motion. Beyond that, I don't have anything more. If you have questions.
Questions from the board at this time?
Nope.
Okay. All right, then we'll move on to testimony. Heather, did we just have one person wanting to speak again?
Yes, sir.
Okay. So we have no supporters to speak. We have one neutral to speak, and then no negatives. So, Mr. Beener.
Again, I addressed this public hearing and it's not listed on the agenda. Necessary to be on point. It is listed as an action item. The only problem is regular meeting, you don't get to speak until the end of the meeting after the vote is over with. So it's really not worth coming to if you want to argue something, but anyway, I think it should be sold to, and I think that in the future, the value should be put on these properties so the public actually knows how much value there is. Thank you.
Okay, duly noted. All right, we have no other speak. Do we have any rebuttal by the appellant or the staff?
Do we? You want to readdress that?
I mean, if the applicant's here, they can certainly respond to the public comment or anything that was provided in the staff report. From legal's perspective, I'll jump in and I'll simply make one additional note. It appears that the applicant in this case is actually different than the owner. The applicant itself was Mr. David McQuade. The owner of the property is listed as the Thomas McQuade Revocable Trust and the Catherine McQuade Revocable Trust. If the property owner is not the applicant, the governing body should be soliciting the opinion regarding vacation of the owner themselves. One can certainly assume, because David McQuade shares a common last name and he's the one making the application, that he is either consulted with the trust or is acting in some fiduciary capacity, whether as trustee or otherwise. However, that documentation is not actually in the hearing packet. So for purposes of legal giving input, I would suggest that an additional condition be that Mr. David McQuade, who's your applicant, provide a copy of the trust agreement, which either denotes authority for him to act on behalf of the trust or obtain a written statement or some other authorization from the owner, i.e. whoever is a trustee of that trust, denoting their non-opposition.
So your suggestion, Mr. Prosecutor, is that that would be a part of the proposed conditions?
If the BOCC wants to move forward with the decision today, it can make it a component of its proposed conditions. If it would rather have that information before it even makes a decision, you can certainly table or continue the public hearing until a later point in time when that supplemental information can be provided.
Okay. And to reword that one more time, a letter demonstrating that they have the authority to speak on behalf of the trust?
Mr. David McQuade is holding himself out as being a fiduciary or trustee of the trust. He can provide the BOCC with a copy of that trust agreement, which denotes that authority. If he is not the trustee or does not have authority, he would need to obtain some sort of written consent from somebody who does have that authority to act on behalf of the trust.
Okay. And would it be appropriate to ask if he's in the room, if I can just ask the question here and now?
You can ask it, and I would recommend you ask it. I mean, obviously this is the public hearing segment, but for purposes of your packet being complete, I think you would want whatever documentation he's going to provide before final approval.
Okay, is he here?
Yes, right behind.
So, my mother is Catherine McQuade, so she is, I'm not a trustee, so it sounds like you'd need a letter from her indicating agreement with this process. Is that what I'm understanding? So she is fully aware of this, she's aware of the meeting, but she's elderly, she didn't want to travel, and she also just did not want to be too involved in this request for the vacation. So I was taking care of this for her. So that's probably an application. If I'd had her sign it, it might have been better, but I failed to do that. So
Yes, what I would recommend to you, Mr. McQuade, is if you can obtain a letter of consent to the vacation from her and supporting documentation, i.e. a copy of the pertinent provisions of the trust that denote that she is the trustee. So that way we can verify that her letter indicating consent is verified and supported by her authority to act on behalf of the trustee.
Yes, I understand.
Okay.
And we can provide, we have a template for the consent, so.
Okay, thank you, Mr. Prosecutor. Do we have any comments or questions from the commission at this time before we close the hearing?
No.
No.
No? Okay, then I would entertain a motion to close the public hearing.
So moved.
I'll second it.
All in favor?
Aye.
Aye. And now we are in commissioner deliberation. Taking into account what the prosecutor has said, does anybody have any discussion, or are you ready to make a motion?
I don't have any discussion.
No discussion?
I don't have any discussion. Well, I'd like to discuss how we want to move forward with the letter of consent to allow David McQuade to act on behalf of the estate and getting a copy of the trust agreement.
So
Do we
I
want
think
to-
we can make that part of our
you wanna make
a
that-
motion
you wanna make it
that
part of the
upon
motion?
receiving those documents and we could approve.
So you agree with that?
Be a part of the approved conditions.
Want to do it in part? Okay.
I'm okay with that.
Okay.
Okay.
That's all I had.
Okay. Does anybody want to make a motion?
Okay. I'll do it.
You'll do it? That just means you have to read through all that. Yeah.
No.
And then remember that we're amending the 4203
Yeah.
and the approved conditions.
All right. So I'll move, based on the findings of facts and conclusions of law set forth in these documents and any additional testimony received, the Shoshone County Board of Commissioners order that an excess of public right-of-way lying outside of the Potlatch Road corridor described in Exhibit A, A3, attached hereto and incorporated herein is hereby abandoned and vacated with easements retained pursuant to Idaho Code 40-2033. The excess public right-of-way lying outside of Potlatch Road corridor described in Exhibit A, A23, and depicted in Exhibit B, A4 is to revert to the adjacent property owner, and case number VAC-1002-23, petitioned by David McQuade for abandonment and vacation of public street or right-of-way. With the conditions that Mr. McQuade will provide a copy of the trust and a letter of consent from Catherine McQuade, the property owner.
So, and then if the additional condition, if I may interrupt, with all fees paid prior to the recordation,
Correct, with
resolution.
all fees paid prior to the resolution.
To the recording.
Record.
Okay. Motion has been made.
I'll second it.
Okay. Any final discussion?
No.
Okay. All in favor?
Aye.
Aye.
Motion is carries, and this has been approved with the conditions outlined. Okay. And with that, we are adjourned.